I'm criminal defense attorney Aaron J. Boria, and today I'm going to be talking to you about how we, as criminal defense lawyers, challenge a drinking and driving case. The first thing that you need to know is that in any criminal case, including a drinking and driving case, the prosecution has the burden to prove each and every element of a case beyond a reasonable doubt. Failure to prove even one element results in your case being dismissed or resulting in you being entitled to a not guilty verdict. In a drinking and driving case, the prosecution must prove, beyond a reasonable doubt, that you were driving a motor vehicle on a public road or a road generally accessible to the public, and that you had a blood alcohol level of a .08 or higher. Each element must be proven beyond a reasonable doubt, or you're entitled to a not guilty verdict. Now, there are three main ways to challenge a drinking and driving offense. The first is the stop. The second is the arrest and search. The third is kind of a extension of the search and has to do with chemical testing. In any police encounter where you're pulled over, the prosecutor has to have a legal reason. He can't just pull you over for no reason. An officer could pull you over for committing a civil infraction, such as not using your blinker, speeding, or running a light. The officer can also pull you over for having reasonable suspicion. Reasonable suspicion means that the officer must be able to point to facts that would indicate that he reasonably believed that you were about to commit or were committing a criminal offense. Some of the things that an officer will point to in a drinking and driving stop is that you were swerving outside of your lanes. That's a very common one. You're driving way too slow. That's also a very common reason. If the officer does not have a legal reason to stop you, then any evidence, including blood alcohol, gained after the stop must be suppressed. If the prosecution does not have evidence of blood alcohol, then they cannot prove the element that your blood alcohol level was a .08 or greater. That charge must be dismissed. The next major area to challenge a drinking and driving offense is in the arrest. The prosecution must prove that the arrest was legal. By probable cause, they must be able to show that a crime was probably committed and that you probably committed it. In order to do that, they're going to look at the officer's report, the officer's testimony. They're going to look at things like, did your breath smell like alcohol? Did you admit to drinking? Did you take a preliminary breath test and fail? Did you fail your field sobriety tests? If these things are there, then the arrest is probably legal. However, if you passed your field sobriety test, if you didn't blow over the legal limit on the preliminary breath test, if the officer didn't smell strong odor of alcohol combined with bloodshot eyes and admission to drinking, then there's a good chance that the arrest was illegal and your case could be dismissed. Finally, chemical testing is another major area of concern with drinking and driving. Oftentimes, the machines used for chemical testing are not calibrated properly, they are not used properly, or the officer doesn't follow the proper procedure. In blood cases, you have to make sure that the person who took the blood is qualified to do so, that they did so in a manner that it will not affect your results, and we also want to take into consideration how the lab handled the blood and did they follow the proper protocols to ensure that your blood and the measurements that they come up with after running their tests are valid. Failure to do this could again result in your case being dismissed. Even if the prosecution is able to prove that the stop, the arrest, and chemical testing were all legally done, they still have to get beyond the reasonable doubt issue. Failure to prove each and every element beyond a reasonable doubt results in a not guilty verdict. Reasonable doubt in a criminal case or drinking and driving case has more to do with the facts and circumstances of your particular case. If you're facing drinking and driving charges in the state of Michigan, give my office a call, 734 453-7806. We know the law, we know how to fight, and we fight for our clients and we protect their rights.